Good evening, everybody. We are going to wait until 7:05. We've got a lot of people that are cranking in right now, so give us a few minutes and we will start shortly. Thank you. Hey, folks, thanks for joining. We still have a lot of people that are coming on, and the Q&A is open. So if you want to get a head start on asking some questions, we will certainly take some of the easier ones to address, but we'll be getting going in earnest about 7:05 Central, 8:05 Eastern. All right, we're getting close to 7:05. Looks like we got a couple of minutes. We got a whole lot more people joining than we've had before, so I'm going to give it just a couple more minutes. All right, folks, it's about 7:05. I think we're going to go ahead and get started. We've still got people joining, but it's a record number. So I'm assuming we're getting there. A lot of questions already coming in. So thanks for joining us. My name is John Humphrey. I am the chairman of the Tort Claimants Committee, the official fiduciary of this process. Been working at it now for almost 20 months. So I'd like to introduce Doug Kennedy, my partner in crime. He is our vice chairman. And then also John Lucas and Jim Stang with Pacholsky, Stang, Zeal, and Jones, our professional counsel. Lot to cover tonight. We're going to focus. There's a lot of questions on TDPs and how much do I get paid and how do you think through that process? And so we're going to definitely cover that. We are hosting these every Thursday night at 8 p.m. Eastern Standard Time. There was a question in there. How long does it take to respond to questions? I'll be honest with you. Sometimes we miss them, and we try to take and download all of the questions from each town hall. If you are sending it to the BSA survivors at pscjlaw.com, I know Steve Golden, who you see up on the top of the screen, he's exclusively looking at all those emails. So if it doesn't get answered, be patient with us. Send it to the BSA survivors email. So Doug, before we get kicked off, you want to say a few words?
Yeah, I just want to welcome everyone tonight. If you're first time to our town hall meetings, we'll be doing these every Thursday, as John mentioned. If you're returning, thanks for being here. It's so critically important. The TCC is really dedicated to you having the best information possible. John mentioned we're going to be talking about the TDP tonight. Also, voting. We're going to talk a little bit about our website. We are so proud of our staff answering questions. Last week, we answered around 200 questions, I think over 200 questions in the hour. It's critically important that this town hall does that for you. As well, I should just mention that we're going to be covering a lot tonight. This video will be downloaded and a link will be posted on the website. So if we go too fast or you can't keep up or it doesn't make complete sense, please just check back on the website in a day or two and you'll be able to see the video.
Yeah, thanks, Doug. And, what I would tell you guys, maybe trust but verify on everything you read, everything you hear in the news. There's a lot of nonsense flying around. I heard a comment by an attorney that the TCC had made $32 million. And, just so you know, the volunteers on the Tort Claimants Committee, we don't get a dime, not a nickel. We're in line just like you guys are to get something under a plan. And the reason that we're voting against this plan is that we don't think it adequately compensates survivors. And there's a lot of room left, I think, in the Q&A. I've already got some questions that are teeing that up, so we're going to save some of that for later. Doug's going to talk a little bit about youth protection. And we're going to cover mostly what the plan looks like, and then we're going to delve into some questions you have around BSA liquidation. There's this misunderstanding that by voting the plan down, we're going to add lots of time in litigation, and it's actually the opposite that's true. The BSA, they painted themselves into the corner when they did that deal with Hartford. We think that the insurance companies, including Hartford, can pay a lot more. So we're going to get into those details later on. With that, I'm going to turn it over to Jim and John to cover the trust distribution procedures, payment. We might throw in a little color commentary, but gentlemen, it's yours.
Wait, one thing there before we get into the trust distribution procedures. A lot of people have been asking, I haven't got my ballot yet, and they are coming. They could be tomorrow. Some people got them yesterday. And so, the ballots are being mailed all over the country. And so the mail systems work a little bit differently. And, there are people that are overseas even, and it'll probably take a little bit longer. Some of your ballots are being distributed to you through your lawyers in an electronic way too. And so that could be some of the delay. But we have a lot of time yet right now. And so it's important to get informed today and tomorrow. And if you don't have your ballot or the other information, please email us and we will help get you the information and get a ballot in your hands or connect you with your attorney so that you could make an informed decision and vote. Sorry about that. That was just a big question.
And I would think by now you will have heard from your attorneys. So I've heard from mine. I got a really long email that said, this is what we're doing. This is when we're going to get it. This is how we're going to distribute it to you. Very detailed. So if you're not getting that, you should call your attorney and ask.
And John, I would just add, and good evening, folks, Jim Stang. We're going to give you website information towards the end of the program. If you want to get a jump start on reviewing the material, even though the ballot may not be in hand yet, or you may not have the book yet from your lawyer, you can go to the website and get an early start on your good snooze. The materials are available, and we'll give you the links on how to get to them if you want to get a head start.
Okay, gents, you're up.
John, you going to take this?
Yeah. So
Okay.
Everybody asks, and it's a great question, what are the trust distribution procedures? And in essence, the answer to that question is they are the rules or the procedures that the trustee will use to evaluate your claim and come up with a value of how much your claim is worth and ultimately how much you should get paid. And so the trust distribution procedures, we will tell you at the bottom of this slide here about how to find them and where they are, but it is Exhibit A to the plan. And it's a document that is fairly complex that sets forth the various rules that the trustee will use to evaluate your claim. The settlement trustee will hire attorneys and other professionals to review the survivor claims. And we will sort of go through below here with an example of how that might be done in sort of very simplified terms. And so let's move on to the next slide. So once you look at the TDP, and you get to page 13, there's something there that we call a matrix. And the matrix will set values for different types of claims. And each type of claim will be given a base value. And so here on the page, you'll see that a penetration claim has a base value of $600,000, a masturbation claim of $450,000, and a masturbation claim by a youth for $300,000. And then each type of claim or category of claim has a different base value. And so once you have your claim there, the amount of the base claim, the trustee will use what are called scaling factors to increase the value of the claim or decrease the value of the claim. And so there are a number of different scaling factors that can be used to increase the claim. So for example, let's assume that somebody was abused just once, or somebody was abused 50 times, or somebody was abused in addition to being multiple times, they were photographed or filmed, or there were threats made to the survivors, to the survivor himself, like don't tell anybody, I'm going to, hurt you or hurt somebody in your family, or the survivor was abused by multiple people. In that situation, the trustee can use a multiplier and take the base claim and multiply it by a multiplier up to 1.5 times. In addition, there are other factors. If the abuser is accused by multiple other survivors, that can increase the value of the claim. And if the claim, and also if the survivor's mental health, physical health, had problems with interpersonal relationships, the ability to maintain a job or to get an education, or actually ended up maybe incarcerated or in jail. All those things can be used to make the claim bigger. But at the same time, there are other factors that can make the claim smaller. And the trustee can assign basically a multiplier between 0 and 1 to make the claim smaller. So it'll go through the first part, identifying different aspects of the claim and using those multipliers. And then it will go through the mitigating part to make the claim smaller. And so in that instance, the abuser, the abuser might have been related to the survivor. Maybe it was the abuser's father, maybe it was the abuser's uncle or some other relative. And maybe because of that, there was really sort of a different relationship than being a scout that maybe led to the abuse. The abuse might have occurred outside of scouting. Perhaps the chartered organization was a church and the survivor was a choir boy or something like that. And maybe it didn't, but the church was also, a scout leader. And so it's hard maybe to distinguish between, did it happen under the church's umbrella or did it happen under the scouting umbrella? And then also, and sort of one of the big ones that we talked about this last week, is that the statute of limitations is another scaling factor that can reduce the claim. So we'll go through here, example. Let's go to the next page. So let's assume that it's a masturbation claim and the base claim is $300,000. And so let's say that the duration of the claim that, let's say that it happened, a number of times for many months or even years. The trustee might say that he or she wants to multiply the claim by 1.2. And let's say that the same abuser was accused by other survivors also, and that increases the claim by 1.25. And so when you multiply 300,000 times 1.2, and then you get that number and you multiply it times 1.25, you get 450,000. Let's assume that the claim or the abuse happened in Michigan. In the state of Michigan, and let's assume that the claim is out of statute, there's a range that the trustee can select to mitigate the claim anywhere between 10 and 25% of the value of the whole there. And so let's assume that the trustee decided that it was worth 25%. And so the $450,000 claim would be reduced because of the statute of limitations to $112,500. This is the final claim amount. So this is the face amount of the claim that you have. And this is basically the award that you have. But this isn't necessarily what you receive, because what you receive will depend upon how much money is in the trust. And so let's go to the next page.
And before you comment on the next page, John,
Yeah.
I would just say that at the current amount that the coalition is talking about, you're not going to get anything close to that amount. And that's the problem, that
Yeah.
this process is a little disingenuous.
Yeah, and to that point, with the current funding of the trust, there's, and if everybody's going to receive something, which is what we all want, then, we estimate that there's enough money to pay about 10% of that $112,500. And, even if you doubled it, and that's what, the coalition says that they're aiming to do, is to double it, maybe it's 20%, but it's probably less, but it's not that final amount that you see there. So let's go to the next page now.
John, let's just hold on for a second.
Mhm.
There's a reason we put the word amount in caps in the title. This is the amount of your claim. This is not the amount of the check you may receive.
Yeah, it's not your payment.
It's not your payment. It is the value. And while it is tragic that people may talk about cents on the dollar or a percentage, it was important, because of the way the plan is structured, to come up with a value for your claim. But if anyone tells this person that they are going to get $112,500, that is a big lie. That's not under the scenario. depicted under the reorganization plan and the aspirations of the coalition, this number will not be filled in on the check. Just not going to happen.
Yeah, and to emphasize what Jim said, and Jim used the words, "That's the big lie." If somebody does get a claim at $112,500, what that means is there will be that many other people who get that much less or nothing at all. So let's go to the next slide, which we sort of talked about already, but we'll get into it just a little bit more
Let's
detail.
do it again.
Yeah. So, I'm sorry. So there is one other way that you could value your claim. You don't have to go through the TDP, but the choice isn't entirely up to you. So instead of having the settlement trustee value the claim and using the matrix and the scaling factors that we just went through, you could look at pages 23 to 26 of the TDP, and you can go into the tort system. And that means file your claim in the court, sue the defendants that you could sue, and have a court determine the amount of your claim. I mean, you might win big, you might lose, but there is that ability to go out there. And so you have to remember that any judgment that you get under this path has to be shared with the trust on a 50-50 basis. That half goes to you and half goes to the trust. And then the balance of any payment that you might be owed, so will be capped at the TDP matrix amount for the maximum amount of the type of claim that you have. And then, so this is one of the other very, very important parts here, is that if you want to take your claim and put it into the tort system, you have to give the trustee a notice, and the trustee and the Settlement Trust Advisory Committee has to agree.
And John, that's an important point. People have to understand that they don't get to just opt out of any of this.
No, you are in the system. And if you want to get out of the system, it's up to the trustee and the Settlement Advisory Committee to let you out.
John, I want to say something more about this. I have been representing abuse survivors in bankruptcy cases since 2004. For those of you who are new, I'll just recite again, 15, 16 committees in Catholic Church cases, that diocese and religious orders that file Chapter 11, USA Gymnastics, we represent the women there, Harvey Weinstein's company. And often people think of this as kind of a class action. And it has elements that resemble a class action, but when people who get those little postcards that tell you that you've won 32 cents because you were a consumer of some service, people say, they go, well, you can opt out. We get those questions all the time. Can I opt out of this settlement? That's not what bankruptcy is about. And people react going, well, I've lost control. And what I've learned from representing survivors is that being in control is really, really important, because you didn't have control when that bastard hurt you when you were 8 or 9 or 11 years old. And so what this process does in the BSA plan that is sponsored by the coalition is to take your control away. You have to get the votes of a trust advisory committee, which will be controlled under the BSA plan by coalition lawyers, and the approval of a trustee to get any opportunity to sue in state court. If those people say no, you are forced, you are compelled to have your claim valued by the trustee. You don't have the choice. So lawyers sometimes refer to this as a gating situation. You have to get through the gate. And you don't get to say, I'm walking through. You get to say, may I? And that is a fundamental problem with the BSA plan that is supported by the coalition. John, you can go on.
Yeah, let's go to the next page, Deborah. So as we said, once the value of your claim is established by the trustee, survivors will only be paid the full amount of that face amount of the claim if the trust is fully funded. And so, as we said before, under the current terms of the plan, the TCC does not see that the trust will be fully funded. At most, it might have twice as much money that it's slated to have in it now. But as things stand now, an adjusted base value claim might receive as much as maybe 10% of that face amount. And so if you look in the disclosure statement at the pages of 41 and 42 of the PDF, or pages 37 and 38 of the disclosure statement, we have a chart that the TCC put in the disclosure statement that describes our view of what creditors will receive under the current terms of the plan. The coalition disagrees with BSA's estimate of the claims. And so, this is really, really, really important because, you could be awarded some claim for $1.7 million, but you're only going to see a very, very, very small fraction of that. And so in the end, that even if you believe that the coalition, as they said at the disclosure statement hearing, that they're going to double the settlement payments, and if you use the future claim representative value instead of the TCC value, it will only result in about a 14% recovery of your claim. So in the example from the prior 2 pages, in the end, you're only going to get about just a little less than $16,000. So let's go to the next page, I think is the last slide. So where do I find the trust distribution procedures? Go to our website, www.tccbsa.com, and there's a link to the TDP. The TDP is also Exhibit A to the plan, and the plan is docket number 6443. The plan and disclosure statement are on our website, and you could also go to Omni's website, and all that information is there. And so we just want everybody to remember that the TDP isn't final. It might be subject to change, and the TDP will only be approved if the plan is approved. And so, this is the part of the process that we're objecting to and trying to change through legal argument, but most importantly, through every one of your votes.
Yeah, I think there's some lack of understanding. And I've heard a lot of people say, gosh, if we don't vote this thing, it's going to just get litigated forever. And so we've got a number of questions here, Jim. And, the first one is about just that. What happens if the plan is voted down? Are we going to be in litigation for a year or two? And you might contrast that with what if the plan is voted and passed, and why might that lead to a little bit more litigation?
So I used the term earlier, the big lie. I'm going to call this big lie number 1. The big lie is if you vote the plan down, we will be enmeshed in 5 to 10 years of litigation. Well, based on the insurance company objections to this plan, that's probably the scenario one's looking at right now, because this plan does not go effective while there are appeals pending. And lawyers can debate whether that's absolutely true or not, but none of the insurance companies that have reached settlements are going to put in all of their money, unless there is a court order that blesses this deal that is not pending appeal. Now, I've been accused of not telling you the whole story. Hartford will put in some of its money, even if there's an appeal pending, but it won't put in all of its money. So as we go through settlements, and really Hartford's the only insurance company settlement there is right now under the BSA coalition plan, just remember, it is not a globally consensual plan. And if there are appeals, that trust will be even more underfunded. So if the plan is voted down, what happens? Well, the earth doesn't stop spinning. I know it doesn't look like it, but as John corrected me last week, I've been doing this for 40 years and doing sex abuse representation since 2004. In the Archdiocese of Minneapolis-St. Paul case, the diocese plan was voted down. The survivor plan was not approved either. There were what we call competing plans. The Archdiocese of St. Paul, Minneapolis did not file a Chapter 7. It did not dismiss its bankruptcy case. It went back to the negotiating table with the creditors committee. And what a surprise, people got more money. In a case presently pending before Judge Silverstein, that's our judge, it's called Imerys. It's an asbestos case involving Johnson & Johnson talcum powder. Last week, 10 days ago, Judge Silverstein threw out certain votes, and that plan, because of her action, because of the certain problems with the ballots that were cast, the plan did not get approved. Imerys did not file a Chapter 7. Imerys did not dismiss its bankruptcy case. And everyone is expected to go back and negotiate so that those no votes can become yes votes. And so this notion that it's going to go to hell in a handbasket is just the big lie. It's not how the real world works. You all have negotiated for cars or for houses, and you know that even if you walk out, you get called back. And that's just what's going to happen in this case if survivors do not support this plan.
So Jim, I've got a follow-up question that we hear along the same lines, and that is, what about this $600 million that the local councils are going to be contributing? Some people say that sounds like a good deal. Members of the TCC have seen otherwise why it isn't, but do you want to address that?
Sure. First of all, it's not $600 million. Let's be really clear about that. It is $500 million and a promissory note. And that promissory note is the amount that's paid under that promissory note, $100 million, depends on how a pension plan performs. The local councils were subjected to intense scrutiny by the TCC. We have evaluated every single local council from public sources of information and information that was provided to us through the bankruptcy. We have appraised over 500 camps and real estate holdings. The BSA has also appraised additional properties, and these values are in the disclosure statement. In our opinion, allowing local councils to keep enough money to continue the scouting mission, they can pay 3 times that amount. So like I said to y'all before, you can say yes and get a deal if you accept the other side's low number. It does not represent a real effort by the local councils to fairly compensate survivors. And if you look in the disclosure statement, and John, I think it's Exhibit G, there's a chart that shows, based on our estimations, how much these local councils are really paying as against their liability as we calculated under the TDP matrix.
Yeah.
And it is pathetic, folks. It is pathetic. It's frankly unspeakable.
Hey, I want to add one thing on what Jim is saying, and I'm quoting Doug Kennedy here, and this is why it's just so unbelievable that the local councils are the ones that issue the charters to the sponsors. The local councils are on the front lines of the abuse. The local councils are subject to billions of dollars in childhood sex liability. And they're here, not even filing their own bankruptcy case. And some of them are just providing or contributing thousands of dollars, some of them a couple of $1 million, in light of the billions of dollars of liability that they have hanging over their head. It's unconscionable.
Well, and when John says they're not even filing their own bankruptcy, we are not advocating that local councils file bankruptcies. But that transparent, the BSA, by filing the bankruptcy, as difficult as it has been at times regarding disclosure of information, has had to put its financial picture in front of everyone and have it scrutinized and have it evaluated. The local councils have not paid that price, yet they want exactly the same forgiveness that BSA can get if the court confirms its plan. And that's really what John's saying when he said they haven't filed their own bankruptcy. We don't think they will, but
Yeah, we've been calling it the
transparency is not
get out
there.
of jail free card between
Right.
the sponsoring organizations and the local councils. So you guys should just be enraged that it's a pittance. And we've looked at their numbers. We know they have enough cash to pay substantially more and still operate the camps and the business.
And Jim or John, do you want to talk at all about this sort of threat that we hear all the time? The Boy Scouts are running out of money and they're the melting ice cube and all that.
Big lie number 2 and 3. It ties into this business about BSA is going to go into liquidation. Well, let's be really clear about what can happen and what can't happen. What can't happen is that the court can force BSA into a liquidation proceeding, which is also known as a Chapter 7. It cannot do that. It does not have the power to do that. BSA, if the plan is voted down, has 3 choices. It can ask the court for permission to dismiss the case. I don't think it's going to do that. It has spent a lot of money trying to get its issues resolved through a bankruptcy proceeding. And dismissing the case means all of that was for naught. And it goes back to as if if one could turn time back, is as if they had never filed bankruptcy at all. Second, they could put themselves into a Chapter 7. What does that look like? Do you think, I used to be a bankruptcy trustee. I was for several years. Do you think they're going to give me as a trustee the Philmont campground to administer? Do you think they're going to file a Chapter 7 case and give me Northern to administer? Or the Summit property? Of course they're not going to do that. Do you think they're going to give me as a trustee hundreds of millions of dollars in what they call restricted cash and investments, which they're telling creditors they can't touch? But are they going to give that to a trustee to fight over? No, of course they're not going to do that. What they're going to do is take a deep breath, probably mutter a few things about the people who voted no on the plan, and march themselves back into a mediation room where they're going to take survivor concerns seriously. And right behind them, walking like little ducks, will be the local councils, and behind them will be the chartered organizations, and pushing to the front of the line will be the insurance companies who want out of this. But so long as they're talking to someone who will take low dollars, they're happy as clams. But that's what's going to happen. So is BSA running out of money? No. The cash that BSA has promised to the trust does get reduced over time. That is true. But BSA has not surrendered all of its cash to the trust. It is sitting on millions and millions and millions of dollars of what they call restricted money, restricted to support the mission of scouting. So this notion that they're going to be forced into a liquidation because this case is going on is big lie number either 2 or 3. I've lost count, frankly.
Yeah. And remember, they have millions and millions of dollars of cash and other property that was good enough to provide the platform for scouting, which led to your abuse, but that same money is not good enough to pay the claims that you're owed.
Thank you, John, for saying that.
And one last thing on this, and then I'll let you ask the next question, Doug. You know, the membership of the BSA, despite the Mormon church leaving years ago, has been in a secular decline for 30 years. And the apex of scouting when we had all those camps and all the activities to support 2 or 3 million scouts. We're down to what number, Doug? Million?
Less than
800,000?
It's 750,000 or less.
750,000. So if you know, if I'm a restructuring guy, I look at the assets that they no longer need to fulfill their mission, and I liquidate those assets. And so these guys are a long way from running out of a balance sheet to live to fight another day.
Doug, can I volunteer one more? And I won't call it the big lie, but can we talk about the Hartford settlement for a moment?
Well,
that was going to be our next question.
That was going to be my next question. And one comment I wanted to make was, we heard from so many survivors over the last week about how they were scared after a town hall that they attended from the coalition on Tuesday night. And I hope people are starting to appreciate that we really just want to get the facts out and be very upfront about what's going on. And we want every survivor to hear this from professionals that have been involved in bankruptcy for decades. And I'm hoping you're seeing the difference with that tonight. So Jim, yeah, please, could you talk about this historic amount from an insurer, which is getting thrown around, why that's such a big deal and so much money?
Well, it is historic. It's historically low. So let's just talk about insurance for a moment. And I'm going to try to really stay, not be an insurance wonk, because honestly, I'm not. I'm a bankruptcy wonk. But we all have insurance, car insurance, property insurance. And there's this concept that insurance pays per accident. Lawyers sometimes call that per occurrence. So the Hartford policies, which go over a number of years, pay I'm a little out of focus, pay $500,000 per occurrence or per accident. In the world of insurance, what happened to all of you is called an accident, or it's an occurrence. Can't deal with that. That's what the insurance industry calls it. So for every claim, you could get as much as $500,000. So BSA went out in an effort to start some kind of momentum and negotiated a deal with Hartford. And originally it was $650 million with some provisions that could decrease it. Hold on, I'm going to see if I can fix that. No, I'm going to be fussy. Oh, maybe it's a little better. And we said no. Remember, we're the party of no. We said no. The coalition said no also. And the court and the BSA went running to the judge and said, Judge, they're all saying no. We had said no before they signed the deal, but they didn't listen to us. And let us out of it because creditors aren't going to support it. And our plan will go down like a sinking ship. And the judge said, you signed the deal. Well, I'm paraphrasing. You signed the deal. You got to put it in front of the creditors. And if you don't, you might, BSA, be responsible for some damages because you made a promise that you'd at least present it. And so Hartford went back. What a surprise, right? They went back and negotiated again. And they negotiated a deal for, it really turns out to be about $785 million. You'll hear the number 787, but they get a rebate. It's really about 785. And the coalition has said, yeah, that's great. They got them up from 650 to 785. Congratulations. There are 24,000 claims, folks, in the Hartford years. Someone should do the math, what that works out per person. So how does that 785 million compare to their exposure, to their risk, to the fact that if you have a claim worth as much as $500,000, they have to pay that amount? And by the way, there's no cap on their liability. If there are 5,000 claims, they pay $500,000 per person, assuming, again, the claim is worth that much. And if there are 10,000, same issue. There's no what we call aggregate limit or aggregate cap. This is a per accident, per occurrence limit. So how does that 785 compare to their exposure? Well, not very well. If you take 1972 abuse claims, just that year. And John, how many years does Hartford have?
There are, I mean, they're just the real great years are 72, 73, 74, part of 71. There are a whole number of years, but using 72 is just a great example. There are many other years.
Right. Tragic years, but great for insurance coverage. In just 1972, and just in claims that have no debate about the statute of limitations, and just penetration claims, okay? 1 year alone, no statute argument, and penetration claims. Their exposure is over $800 million. They're paying $785 to get out of liability that spans many years. And 1 year alone, for one category of abuse, is $800 million. So is that a historic settlement? Yeah, it's historic. It's historically embarrassing because they have a lot more exposure. So that's why the Hartford settlement is unacceptable. And if you use the Hartford settlement as a template for the other insurance companies, folks, it's just not going to be fair and reasonable for what you've endured. Just isn't going to be.
So on that same theme, Jim, before we finish this set of questions, there was a question about the sponsoring organizations. I think we've referred to that as the get out of jail free card. Could you explain that a little bit to people?
Sure. So if your lawyer is going to represent you in actual litigation, there are 4 people who are going to get sued for your abuse. The Boy Scouts of them, and I'm talking about as defendants. The bankruptcy obviously limits your ability to actually sue people. You got the BSA as a defendant. You have the local council as a defendant. You have the charter organization as defendant. And of course, you have the perpetrator. So BSA has been struggling with what to do with the charter organizations because the insurance companies want finality. They never want to hear the word the title, Boy Scouts of America. So they need to get a release and resolution with the Boy Scouts. The bankruptcy facilitates that. They want to get a release and finality with the local councils. That's the $500 million settlement plus the promissory note. But they need to deal with the chartered organizations because the charter organizations are part of that insurance program that the Boy Scouts had. And the charter organizations have their own insurance, totally separate. I mean, this is a Kiwanis club that has its own liability policy, doesn't have anything to do with the Boy Scouts insurance. People go in and out of their building, people slip, they fall, they have their own insurance. So what is the settlement they're proposing? Well, they need to get the insurance control over the insurance because they can't make insurance deals without control over the insurance to say to the insurance companies, you're done, you're finished, we took care of it for you. So they've offered the charter organizations this great deal. Give us your insurance policy coverage and you're done. So now they have the insurance policies in hand. They can deliver them to the insurance companies with a settlement and the chartered organizations pay zero. All they have to do is agree that their insurance can go over to the control of the settlement trustee and be done with it. Now that is for claims from January 1, 1975 forward. That's the deal. Deliver your consent to us controlling your insurance coverage that was part of the BSA program, and you get out of jail free. So for the claims that are before January 1, 1975, there's no deal. Now, someone might say, well, Jim, how do you expect them to chase all these charter organizations? I mean, it's like herding cats doesn't even begin to describe the situation because there's so many of them. Well, apparently not that hard, because guess who's paying guess who's paying money? The Church of Latter-day Saints. $250 million. By the way, only for Mormon survivors. That was a requirement of the Church of Jesus Christ of Latter-day Saints. And it just seemed to me, well, if you got money from them, why can't you get money from the others? Why were you in such a rush to give these people a free pass? I mean, my God, they're the ones that decided who your volunteer was going to be, who your scout leader was going to be. They're the ones who didn't watch the tent that night or make sure that you weren't alone with that pervert. Now, there were others too who are responsible for that, but let's not forget how these folks were selected and who was responsible for selecting them. So that's the get out of jail free card. Give us your insurance. You don't pay a dime unless, of course, you're Church of Latter-day Saints, and you get to walk away.
Hey, John and Doug, I saw this question asked in the Q&A, and we also, Steve and I also got it sent to us a number of times this week. And so do you mind if I sort of, set the table here on this next one? So when a company goes in Chapter 11, a committee is formed, like the Tort Claimants Committee, to be a counterbalance to the debtor. Because the debtor is going to say, we don't want to pay anything, but there's this committee here that's here advocating for the interest of all the survivors to make sure that you're going to get paid as much as possible. And so the committee has 9 members. John and Doug are the co-chairs of the committee, and there have 7 other members that work every week on this. But what the committee gets to do, and this is no different than any other bankruptcy case, is that they get to hire professionals. They get to hire lawyers, and they hired Pacholsky Stain as their bankruptcy counsel, and they hired BRG as their financial advisor. And we have a few other professionals that are helping us advise the 9 committee members. And I'm not going to mince any words or anything like that, but we get paid. And we get paid by the Boy Scouts. The Boy Scouts pay my firm's fees. And we have earned a lot of money in doing that. And we're not going to make any bones about that. But what we did, and on the first day that Doug and John decided to hire our firm, we told them that 10% of all the money that we're going to make, we're giving to the settlement trust. We're contributing the money that we're going, and it's going to the settlement trust. And so the coalition has made out that, oh, we've made so much money, and we have made a lot. We're making money here. There's no question about that. But we're the only ones that are trying to give something back. And you know what the coalition is doing? They're asking the bankruptcy court to have the Boy Scouts pay their bankruptcy professional fees, of which is estimated to be at least $15 million. And I want everybody to understand what's going to happen if that's ever approved. That means that the BSA has that much less cash in the pot that it's already decided to contribute to put into the trust. And so,
I'm sorry, John.
no, I'm good.
Okay, I just wanted to add that that 10% we offered after we were hired, not before, as an inducement to hire us. Yeah, I mean, the bankruptcy court is concerned about this issue of the payment of coalition fees. She has referred to the fact that the coalition representatives had said it's not coming out of survivors' pockets. But of course, if it's coming out of the pot, it is. Perhaps indirectly. You won't see a deduct on your check for that, but it does lessen the amount. And she expressed concern about duplication of effort. You know, what has the coalition done that the TCC wasn't doing? And I think I can answer that question. They took lowball settlements, but I don't think that's a reward. I think that's a demerit.
And let me also point out too that the TCC has a finance committee. It's led by a retired Army officer, and every single bill from every single one of our professionals is reviewed, and nobody's going to tell that man and the other people that review those accounts that money isn't earned and isn't reviewed. It is, and it is. We interviewed firms, we chose the firms we chose, and we think they're the best in the country.
Yeah, and the Boy Scouts are paying those bills.
Exactly.
So John, any other questions
Yeah,
that we should
well,
address online?
I want to maybe say, and maybe this is sort of how we sort of try to segue into trying to wind this down. And remember, everybody, we're doing this, the same link, same time next Thursday, and we're going to do this again. But we've seen that people have a bunch of voting questions. What do I do about the opt-out? You know, real quickly on the opt-out is voluntary. It has nothing to do whether you opt out or you don't opt out. It's not going to change anything on the way that this plan is dealt with. If you don't know, if you have other claims against the Boy Scouts and its directors and officers, then opt out. I mean, in all cases, you should talk to a lawyer if you have one, but opt out. It isn't going to change anything. If you don't know, opt out on that. On the $3,500, people have been asking questions about the $3,500. If you want to just be done and you have the minimum level of a claim, check the box for the $3,500. You're open to do that. That's up to you. You're only going to get it if the plan is approved, and you could vote to accept or reject the plan. You're not wedded to one thing or the other. And then obviously the two other most important things on the ballot is to either we recommend rejecting the plan, or you can accept the plan, obviously, too. And at the end of the ballot, or sort of like, I think it's on pages like 10 or something like that, your name, your address, your signature, the date you did all this stuff, fill out all the details. And we are going to talk next week again about the ballot, because we know that people have more, you'll have the ballot in your hand next week if you don't have it now. We'll talk next week about the ballot, and we'll talk about where do I mail it? And if I'm not going to mail it, how can I upload it through the internet to Omni? And we'll talk about both of those things. And I think we'll even have a little bit of video that we could put up on the website for everybody to see. And I'll turn it back over to John and Doug, and maybe they could talk a little bit about the website some more.
Yeah, so we're going to try to put a wrap on here. Doug, I'm going to ask if you'll sort of finish us up. I know that you had some comments around youth protection and where some of the language in the current plan came from. And then
Yeah, John, I'm going to make that a little bit of a coming attraction. First, I want to thank the folks tonight, our attorneys that were behind the scenes. They've answered over 200 questions tonight. And we know that there are questions that we didn't get to. We're going to be talking about these. We debrief immediately after these meetings. They're going to help to form some of what we talk about next week as well. I want to give you a little bit of a coming attraction for next week. In the last couple weeks, I've answered about 100 emails from survivors, and every member, and I've passed those on to the members of the TCC. Every one of us has been touched by how many people said, this, of course, is about the money and trying to make what happened to me, make it a little bit more right. But I don't want the abuse to ever happen again. I want a plan that's going to make me feel somewhat secure or comfortable in the notion that this abuse will stop. And the TCC have been leaders in that. And next week, I'm going to start the meeting by talking about how we've been leaders in that. And there would be parts of this current plan that wouldn't be the case if we hadn't written them. But more importantly, I'm going to talk about the parts of what we wanted to have happen that were taken out by the Boy Scouts and taken out by the coalition. In the last week, we've had headlines about how one person is going to be now, one survivor is going to sit on the Boy Scouts board. And much like this settlement being just insulting and not enough, I think that speaks a lot, everyone. That's one survivor on a board of 40 in a closed room. The TCC would never accept anything like that. So I'm going to talk about that next week. And I just want to close by saying something to everyone. About 24 hours ago, I received an email from a survivor.
And he's listening tonight. And last night I found out from him that he was abused by the same person who abused me. And I want everyone to know out there, him and everyone else, that the 9 of us are never going to scare you. We're never going to mislead you. We're never going to tell you anything but the truth, and we're going to fight for you. And I want to thank everyone that emailed us this week to say they're too smart to be scared off by a bunch of attorneys that just want a payday quickly.
Amen.
We're going to do better. We're not the party of no, we're the party of better, and we're going to fight for all of you guys and girls.
Yeah.
So thanks so much for staying informed, and I hope you'll join us again next week.
Thanks, Doug. Hey, Deb, before we close, can you put up the new, the TCC BSA website? Just so you guys know that we've revamped it. There's a lot of information there. And now I'm just doing the tap dance, waiting for Deb to put it up. But really, it's
There
great.
it is. There it is.
Yeah, so we really tried to streamline it. You can request a ballot from here. There's instructions on how to vote. There is our letter for rejecting the plan. There's a scaling factors that I've answered several questions on scaling factors. If you go down there, you'll see the Zoom link, links to trust distribution procedures, all of the historical town halls, press releases, links to the actual plan itself. So we hope that you will take that link and distribute it to others. We think it's, the information that you need is out there, and we think it's in a much easier way to consume. So
Yeah.
With that, it's 8 o'clock, and I'm going to say thank you all for your time. Appreciate you, Doug, man. You got a heart of gold.
Yeah, thanks to
You guys
everybody.
need
Thank
to know
you,
that
John.
we are fighting the good fight, and we will not be intimidated. Thanks, everybody.
Good night.
Have a good evening.
Good night.